Hi, welcome to Been There Done That. This channel is all about employment tribunals and all the things you need to know so you can represent yourself. In this video, I'm going to introduce you to the Solicitors Regulation Authority, and knowing who they are, what they do and what their code of conduct is might really help you in your case. So let's get into it. If you are up against a respondent who is represented by a solicitor, the solicitor will be under the Solicitors Regulation Authority's Code of Conduct. The Solicitors Regulations Code of Conduct is broken into 4 categories. All of these are not all relevant to you all of the time, so I've picked out the key ones that are relevant to you and how you can use them to your advantage. So, within the category of maintaining trust and acting fairly, there is a clause, which is clause 1.3, and it says the following. You will perform all undertakings given to you and do so within an agreed timescale, or if no timescale has been agreed, then within a reasonable amount of time. Now, this is a code of conduct rule that they are legally required to abide by in order to keep their license. However, a very common tactic when going up against an unrepresented person such as yourself is to waste time. It's to cause delays, it's to have limited availability for things like hearings, to force the tribunal to book them further and further into the future and leave you waiting and hanging and agonising. More opportunity for them to try and negotiate a settlement with you that might be a lower amount than you would have settled for otherwise, but because you're waiting so long, you just think, I want it to be over. They know all of that. They know that you just want it to be over. They know that nobody wants to go to court. And they use that to their advantage sometimes. So it's useful for you to know that in order for them to keep their registration, they need to abide by the Code of Conduct. And in the Code of Conduct, it tells them that they must do these things within the agreed timescale. So if there's a deadline for witness statements or for the bundle, they must meet those deadlines. That's part of their role as a solicitor. But also, if there isn't a timeline given, if you're just talking about rearranging another hearing, they should be doing their part in those things in a reasonable amount of time. So if you find you're up against a particular litigant who likes to waste time, defer things, cause delays, bring this up. The second one I think is useful for you is point 1.4, which says, you do not mislead or attempt to mislead your clients, the court or others, either by your own acts or omissions, or allowing or being complicit in the acts or omissions of others, including your client. This one is key. What this means is they cannot allow their client to tell a lie. They cannot allow their client to hide evidence. If the solicitor becomes aware of a piece of evidence, whether or not it is useful or harmful to their case, they must make sure that that piece of evidence is shared. By not doing so, that is an act of omission and that is in breach of this code. I don't believe that all solicitors follow this rule to the letter. I think there'll be many out there that say, I'm going to pretend I didn't see that, Mr. Jones, so please hide it from me, because that blows our case out the water. We're going to have to accept that we are the losing party in this case. I'm sure there are plenty of solicitors out there that do follow these laws to the letter, and I'm not here to criticise solicitors generally. However, it's really important to note that in the Code of Conduct, which their licence is linked to, it says that they cannot mislead or attempt to mislead anyone, nor can they be complicit in somebody else doing so, even if it's their client doing it. This one is really, really important, and I want you to memorise it, because when you're in the courtroom, when you're preparing the bundle, when you're exchanging witness statements, if you believe that something is being omitted that would help your case, this is what you need to be leaning on in order to get that resolved or to get them to be held accountable for their actions. The next one I think is really useful is almost all of the section 2, but the most important ones are as follows. 2.1 says, you do not misuse or tamper with evidence or attempt to do so. If you think that they have tampered with some evidence, they can't. 2.2 and 2.3 are similar, and they're both very important, so I'm going to read you them both at the same time. 2.2, you do not seek to influence the substance of evidence, including generating false evidence or persuading witnesses to change their evidence. And 2.3 says, you do not provide or offer to provide any benefit to witnesses dependent upon the nature of their evidence or the outcome of the case. This is basically saying you cannot witness tamper. You can't encourage a witness to say something that might not be true or to embellish on a point. You can't promise them some sort of incentive if they decide that they will or will not represent the respondent in the court proceedings. This is the sort of thing that you probably imagine might be going on in the background, but solicitors are not allowed to do that. And the last one, I think this is the most important one, so I saved it till last. The last one is 1.2, and it says, you do not abuse your position by taking unfair advantage of clients or others. I think this is the most important one, because if you are unrepresented, it would be quite easy for somebody who knows all the laws, knows the court system inside and out, may have come up against that judge before, to abuse their position and take an unfair advantage of you. They might persuade you in a conversation that your case isn't very strong and that you should settle. They might persuade you that I can't give you any advice on your case, but I would strongly urge you to take advice on your case because you are very unlikely to win. That sort of thing, that sort of language, it's not acceptable. They are taking advantage of the fact that you aren't a lawyer, that you haven't done this before, that you don't know what you're doing, that you're probably feeling anxious and frightened, and you might be unprepared, and you might be just wanting it all to finish and to go away. That's how they convince people to settle for small amounts, especially on cases that they know are worth a lot. So if you find yourself having a conversation with them because you're organising the bundle, or because you're having a discussion about a potential settlement, remember this rule. I hope this video has helped you. I think it's really important to learn these rules. So head on over to www.sra.org and you can read them for yourself. You might even find more that are useful to you. Jot them down, have them ready, be armed with them when you go to court. Best of luck. Please like and subscribe if these videos are helping, and I'll see you on the next one.